So good morning, everyone, and welcome back to our weekly webinar series. We're taking up something a topic which is very popular within IBC. A lot of companies, solvent companies, go for voluntary liquidation. And today we are going to share all the practical insights that we have gathered through our experience with all of you. Over to Anil, sir.
Thank you, Ankit. Welcome to 130 episode of AAA Weekly Webinar Series. The most important development that has taken place is the interest of the participants in the webinar. We have seen a peak in the interest of the participants. In case you would see the last few episodes, we have started spending substantial time on question and answer sessions. Now, we have already done a webinar on the voluntary liquidation. So today we are focusing on what are the latest developments on voluntary liquidation, the practical aspects, and most of the time would be given to the question and answer session. Because if one person asks a question, then the benefit goes to all 300, 400 people who are participating in the webinar. So therefore, today we would be spending substantial time on the question and answer session. Please be ready with your questions. And I would only request, please don't ask repetitive questions and be attentive to the answers that we are giving for the questions. So, Ankit, we actually would like to discuss today the kind of, there are not many judgments. So although we have a kind of narrative today when I circulated that we would be discussing on the latest and all the judgments on the insolvency voluntary liquidation. But yes, there are some judgments also. And before we even go to the judgments, I would very quickly talk about the practically what exactly is the voluntary liquidation. Voluntary liquidation, the primary something which has to be met. It is basically a decision of the company to liquidate itself and without any haircut to any creditor. So if the management and the shareholders of the company feel that the company is no more required, there is no business, or the objective for which the company was incorporated has already been met, then the shareholders and the management can decide about liquidating the company. This is what is called voluntary liquidation. And the difference between the voluntary liquidation and liquidation is that in voluntary liquidation, 100% debt has to be paid or settled by the management or by the company. In the case of the liquidation, then it all depends upon the liquidation estate, value of the liquidation estate of the company, that who would be paid, and all rest of the people, they would not be paid and their dues would be completely written off. So the key factors that we actually can see that yes, there should be a decision of the directors, then there should be a decision of the shareholders. Now, how to start with this? So, the first step is that in a duly convened meeting of the board of directors, or in case it is a limited liability partnership, then the designated partners, majority of them, they should make a declaration that the company should pass a special resolution for voluntary liquidation. And they should also give a declaration that the company is solvent. So that is the solvency declaration, which actually would be triggered, and then we can call it as the day zero when the process of liquidation starts. Then the maximum timeline is that within 4 weeks. Within 4 weeks of making such declaration in a duly convened meeting of board of directors or designated partners, the company must pass a special resolution under the Companies Act for voluntarily liquidating the company and also appoint a liquidator. So when this special resolution is passed, that is what is the liquidation commencement date. On the date when the special resolution is passed, then that is the date on which the liquidation process starts and the liquidator is appointed. Then the liquidator, whosoever has been appointed, within 7 days of his appointment, he will have to inform the IBBI regarding such appointment. Then, in case after the members passes a special resolution and company is having creditors in the books of account, then the two-thirds of the creditor value-wise must approve the resolution passed by the shareholders of the company, that special resolution which was passed under section 59 subsection 3 clause C. That resolution has to be approved by the creditors by way of voting or by way of a meeting. So it all depends how many creditors that we have. So value-wise, two-thirds of the creditors must approve that resolution, special resolution. And of course, nothing to say that whenever you pass a special resolution, you have to comply with some of the requirements of the Companies Act. You have to file a GNL, I believe GNL 2, Ankit. Then immediately after that, within 5 days of the appointment of the liquidator must make a public announcement in Form A of their inviting the claims from the creditors. And in these cases, when the books of accounts of the company is updated and based on the books of account, which should not be more than 14 days older, the liquidator also should send communication to individual creditors so that they file their claim. At this very moment, the liquidator is also supposed to send communication to all statutory authorities. All statutory authorities, when I say, wherever the company is registered, wherever the company has dealing, may it be central government, state government, or regulatory authorities, at all these statutory authorities. Now, why I'm saying every company can have different statutory authorities. In case of a real estate, it can be even RERA, it can be even director town and country planning. It can be any other authority with which the company has some dealing. Nothing to say, there are general statutory authorities, like if the company is registered with GST, then GST authorities, income tax authorities, registrar of companies authority, registrar of company, and then the provident fund authorities, ESI authorities. So wherever the company is registered, even if the company is registered before the Shop and Establishment Act, so at all these authorities, even in the Factories Act, so before all these authorities, the communication has to be sent by the liquidator for the purpose of filing their claims or filing their objections. Then in the meantime, the liquidator will open a liquidation bank account, and all the transactions of realization of assets and distribution will have to be done through the liquidation bank account. Then a preliminary report has to be prepared within 45 days from the liquidation commencement date, and this preliminary report will be submitted to ROC and to IBBI. So there are contents of the preliminary report. I'm not going in detail because we are just trying to have a very, very brief introduction of the process, and then we will go on the practical issues and also the case laws. After the preliminary report, then the question is the verification of the claims received. The liquidator will get 30 days time in verification of the claims. And in case there is no claim received, because see, here the liquidator will also have to prepare a list of stakeholders within 45 days from the last date for receipt of claims. from within 45 days from the last date for receipt of claims. Why? Because 30 days the liquidator is getting for verification of the claims and 15 days for the preparation of the preliminary report. However, in case there are no creditors, in case there is no claim received from the creditors, then the list of stakeholders has to be prepared within 15 days from the last date as per the public notice for receipt of claims. Then in the meantime, the liquidator can start realization of assets. That is not restricting, even if the claims are invited. I believe immediately after the public announcement, immediately after informing the IBPI and ROC, immediately after informing the statutory authorities, the liquidator can start realizing the assets. And that work may take a little more time depending upon what kind of assets the company has. Then at this moment of time, the liquidator also have to see whether there is any uncalled capital or unpaid capital contribution. So the liquidator will reach out to all the contributories and will ask for the contribution which is pending towards their share subscription, and they will have to contribute within 15 days from the notice of the liquidator. That is what is the law says. Now, the whatever is realized by the liquidator, it has to be distributed to the stakeholders, to the creditors first, as per Section 53. So therefore, the Section 53 is again applicable. In fact, starting from Section 35 to Section 53, it is applicable to voluntary liquidation also. So when we see Section 35 to 53, all these sections like Section 40, Section 43, 45, 49, all this actually would be covered. So there is a possibility of like preferential transactions or undervalued transactions. However, we will come to that, what exactly the impact of the preferential avoidance transactions on a voluntary liquidation when all the debts are paid. So what exactly we are trying to see? We are trying to save the money of the shareholders. In case we find any transaction which has actually been done by the management of the company, which is impacting the value for the shareholders, the liquidator is duty bound to take action on the suspended management so that the value and the value for the shareholders is protected. So therefore, the preferential transaction, extortionate credit transactions, and the undervalued transactions, even with fraudulent intent, those are covered for even voluntary liquidation also. So all the liquidators, voluntary liquidators, they are also supposed to see whether there are any transactions under Section 43, 45, 49, or 50. 66 is not applicable. 66 is not applicable because the very first declaration that the management is giving, that the purpose of liquidating the company is not to defraud anyone. And we are able to pay all the debts and the company is solvent. So based on the very first declaration, the Section 66 is not brought in the purview of the liquidator. Then the whatever is realized by the liquidator has to be distributed to the stakeholders under Section 53, and whatever is left will go to shareholders. Now, earlier this particular period was 6 months from the date of distribution, from the realization, but now it has been reduced with effect from 5th of April 22. It has been reduced to 30 days. Now the liquidator are supposed to distribute within 30 days from the date of realization of the asset. So then in the meantime, there may be some objections from the statutory authorities. The liquidator will have to attend to those objections. The liquidator will have to give a reply to them. Then is the final submission of final report. The final report that has to be within 270 days from the liquidation commencement date, where the creditors have approved a resolution, where the creditors are there and the creditors have approved the special resolution. In those cases, 270 days, the last date when the submission of the final report is supposed to be there. And in case there are no creditors, then 90 days from the liquidation commencement date, all this liquidation, the final report can be submitted. Final report can be submitted, and the final report has to be submitted to NCLT, also to ROC, and to IBBI. So this is the first communication to NCLT in the case of voluntary liquidation. So in the case of voluntary liquidation, unless there is a dispute regarding admittance or rejection of a claim, otherwise this will be the first application which will go to NCLT. Now NCLT will see all this. NCLT will also see the compliance certificate in Form H. Form H as provided in the voluntary liquidation regulations of IBBI. That Form H is actually very, very exclusive. And if anyone can read Form H, he will actually be understanding the entire process of voluntary liquidation. Then the liquidator will be responsible for preserving all the records of the company, and all these records and all these reports and records would be preserved for 8 years after dissolution. So this is the primarily the process which I can say within this process. Now we'll come back to various various provisions where we have seen some or the other issues which actually can give us some further enlightenment. So in one of the case where in the case of Harish Khurana, the liquidator of TEIL Project Limited, in voluntary liquidation, this judgment actually came on 22nd of May 2020. In this case, finally there was a dispute whether in the voluntary liquidation process the liquidator has the power to adjudicate claims or not. So finally the NCLAT held that the liquidator can because as I said that section 35 to section 53 is applicable to voluntary liquidation very clearly. So therefore, when we see section 42, that is the section 42 is actually the right of appeal before a claimant. So therefore, NCLAT says that the liquidator has a right to reject a claim and accept a claim, adjudicate a claim, and the rejection of claim can be appealed before the NCLT under section 42. Therefore, the liquidator in fact was saying that that power is not there. So the NCLAT said that the powers are there with the claimant to file an appeal under section 42 of the IBC. So therefore, it was held that section 35 to section 53 of IBC is applicable to voluntary liquidation processes. Now, there's an important judgment from, again, NCLAT principal bench. This judgment is slightly latest, like 1st April 2024. This is in the case of ISCON Infra Engineering Private Limited versus Central Bank of India. So in this case, the fact was that there were some bank guarantees. In fact, the huge amount of bank guarantees, which is a corporate guarantee, not bank guarantee, corporate guarantee. Now, the company which is like ISCON Infra, the company where the voluntary liquidation is sought, this company has given corporate guarantee of 1,257 crores for granting the loan given to another company, another group company. And there are 23 outstanding charges registered before the ROC. The corporate guarantees are outstanding but not invoked. Now, the legal issue which was there, legal issue was whether the corporate debtor can be liquidated liquidated under Section 59 of the IBC, that is voluntary liquidation, while it remains liable as a corporate guarantor for significant debt, even if the guarantees have not been invoked. NCLAT principal bench, Justice Ashok Bhushan, in fact, held in this case very clearly that NCLAT upheld the NCLT's decision, stating that the fact that the guarantees have not been invoked did not absolve the company from its liabilities as a grantor. The appeal, in fact, NCLT rejected the voluntary liquidation, and the appeal was also rejected by NCLAT, saying that the company cannot proceed to be liquidated under Section 59 if the ongoing obligations regarding corporate guarantees are still outstanding. That's really very important. And the another case where the although practically what we are trying to say is there was a company in the case of this is NCLT judgment from Hyderabad bench in the case of Shailesh Baheti, the liquidator of Reconstructive Surgery India. So in fact, this particular company was it was incorporated under Section 8, subsection 6, basically for charitable companies, and this company could not get the Foreign Contribution Regulation Act approval. So therefore, they decided to liquidate the company voluntarily, and the liquidator was appointed. So the basic issue was whether the company can be voluntarily liquidated under Section 59 of the IBC without revoking its license under Section 8, subsection 6 of the Companies Act. It was objected by the Registrar of Companies. NCLT rejected the objections from the ROC. NCLT said that the company could not get FCRA registration. Company is not doing any business. So whatever approval or license has been granted by ROC under Section 8, subsection 6 of the Companies Act, that is not applicable in this case, and the company can be rightly liquidated. Now, the other issue which is important is in the case of, it has come from Kolkata bench, the date of the judgment is 12th of January 2024, and it is in the case of Kuldeep Verma, liquidator of Manthan Broadband Services Private Limited. And the primary issue in this case was whether the liquidator can proceed with the sale of pledged share as part of the liquidation estate, and whether the rights issues and valuation concerns raised by another person could block the liquidation process. Now, in this case, the objections, in fact, NCLT rejected the objections of the other party, and NCLT allowed the liquidator to proceed with the sale of shares, noting that the security interest claim was required to be made within a time limit, and it was not submitted within the time limit. As a result, the shares were deemed part of the liquidation estate. However, see, like in the case of voluntary liquidations, the secured creditors, they have an option of dealing with the security interest outside the liquidation process. They can keep their security interest outside, and in case they would keep their security interest outside the liquidation process, then the liquidator will only watch whether they are able to sell, and any kind of additional amount which they will recover will come back to liquidator. That's a process which is defined in the regulation, but the secured creditors has the option to stay away from the liquidation process, voluntary liquidation process, and they can realize their security interest outside the liquidation process. In another case, the principal bench, New Delhi, in the case of Amit Jain, the liquidator, versus Multix Owners and Users Welfare Society. It has come from the Justice Ashok Bhushan, NCLAT, and the primary issue in this case was because see, in this case the NCLT allowed the intervention application by Multics Owners and Users Welfare Society, and with the finding that the corporate debtor, that means it was a corporate debtor, was Aisher Polaris Private Limited, that was in voluntary liquidation, concealed the service provider agreement. Now, this is a judgment where, in case a company, for example, a company uh, has an agreement where the company will provide a kind of warranty or guarantee, or will provide service after the sale or after a particular event for few years. So this is a case where the society, Multics Owners and Users Welfare Society, they in fact argued that this company, which is proposed to be liquidated, has an obligation towards service provider agreement, and that service provider agreement has not been shown as a kind of a responsibility of the company to, uh, to provide all those services, and there is a value for those services. And in case the company would be liquidated, then who will provide the service to us, which has been uh, taken over by the company as a responsibility by way of a service provider agreement. So in this case, NCLAT Justice Ashok Bhushan held that the society's claim of concealment is unfounded. The service provider agreement was mentioned in the company petition, though inadvertently it was not annexed. And the court also found that the liquidator did disclose the service provider agreement, and the court set aside the adjudicating authorities finding that the liquidator approached the court with unclean hand. Therefore, the court analyzed that the company petition and found clear references. So the court observed that the communication and therefore the concealment which was alleged was lacking merit. However, in my understanding, if there is any obligation is pending against warranty, guarantee, or any kind of service, even after sale service, that company cannot be liquidated unless the entire arrangement is arranged or it is provided for, or somebody else is given the responsibility for handling those service agreements, warranty agreements, or even after sale service agreements. Now, there is another judgment which is uh, so, like, I'm not saying that all the judgments I would say, but then there are some judgments that it is finally found to be very, very clear that this company was supposed to be liquidated, so it has been liquidated. Then the coming to the some judgments, give me a little bit of time. I'm trying to find out the important ones that I would like to share with you. Yes. You see, like, we can, Ankit, move on to some of the questions. Like, if like I have been getting some questions, and I'm just trying to take out some questions from those which are actually comes to us. Like, the first is, what are the prerequisites for initiating the voluntary liquidation under the IBC? It is very clear. Section 59 says that the company must be solvent. There must be a declaration by the majority of the directors or partners, and a special resolution must be passed. This is what exactly has been held. These prerequisites have been held in the case of Krishna Enterprises versus Ratanlal Agarwal. It is a NCLT case. This particular case clarified that these are the prerequisites. Who is eligible to initiate a voluntary liquidation under IBC? Section 59 says that the company, corporate person, limited liability partnership that has not committed any default can initiate voluntary liquidation, and the decision must be made by the members, means shareholders of a company or partners for LLP, through a special resolution or resolution of partners. Now, what is the role of the shareholders in the voluntary liquidation process? Again, Section 59, subsection 3 says that the shareholders to pass a special resolution to initiate the voluntary liquidation. If the creditors exist, the creditors will approve this resolution. The shareholders also appoint liquidator. This particular clarity was given in the case of Simplex Engineering and Foundry Works Private Limited versus NCLT Mumbai, and this was in this particular judgment it was highlighted the requirements of shareholders resolution in the voluntary liquidation. Now, the declaration of insolvency, which is supposed to be provided under Section 59, subsection 3, clause A, what is the significance of this declaration? No, this declaration is basically the threshold for even entering into the voluntary liquidation process. The declaration of insolvency is mandatory and must be made before initiating the voluntary liquidation process. This is again mentioned in that case that I've already said, Krishna Enterprises versus Ratan Lal Agarwal. This was also very clearly mentioned in that particular case. Now, the other question which comes in mind is how is the liquidator appointed in voluntary liquidation cases and what qualifications are required? The liquidator, the answer which is provided in Section 59, subsection 3, clause B, the answer is provided that as the liquidator is appointed by the shareholders or partners through a special resolution, not through the management, but it is by the shareholders or by the partners it is appointed. The liquidator must be a registered insolvency professional, and Regulation 6 of the voluntary liquidation process regulations provide the criteria and qualifications required to be a liquidator. So this was clarified in a judgment called Sai Motors versus NCLT Mumbai. That was the case highlighted. This case had come from NCLT Mumbai. Can a company initiate voluntary liquidation while under investigation or facing litigation? This is provided in Section 59, subsection 3. The voluntary liquidation is allowed only for solvent companies. If a company is under investigation or litigation, like criminal matters, voluntary liquidation cannot be initiated. This was again held in the case of Praful Nanji Soni versus Registrar of Companies in 2023. It was held that the companies under investigation cannot commence voluntary liquidation until such matters are resolved. Further, Ankit, how does the role of the liquidator differ in the voluntary liquidation as compared to the other insolvency processes? Under Section 35, the liquidator of a voluntary liquidation or normal liquidation has similar powers, like a resolution professional, but focus is on the maximizing asset realization, verifying claim, and distributing proceeds. Now, there is no difference in the powers because the law very clearly says that Section 35 to Section 53 is applicable to voluntary liquidation processes. So this was clarified in the case of Kamal Industries versus Techno Trust Limited, where it was illustrated that the liquidator manages asset sale, distribution, and it is different from a RP who oversees the CIRP. The liquidator is not supposed to keep this company as a going concern. Some of the questions on the procedural aspects. What is the timeline for completing the voluntary liquidation? No, the voluntary liquidation, like technically, we should actually file, as we have already said, that we should file our final report within 270 days. And overall, including the NCLT order, it should be finished by 1 year. And after that, it would be requiring an extension. And that extension actually will be applied to NCLT, and NCLT will ask many questions. If the process cannot be completed within the stipulated time due to litigation or unresolved claims, an extension may be requested from NCLT. Extension can only be allowed by NCLT. That was held in the case of MK Agrotech Private Limited. It is from NCLT Bangalore in 2023 that the extension can only be given by NCLT. See, then again, what are the immediate steps after the company's members passes the resolution for voluntary liquidation? The immediate steps are that the the liquidator must file a resolution with the Registrar of Companies and IBBI, and the public notice for inviting claims. So then notification to statutory authorities and creditors that is required so that they file their claims or objections. Again, what are the roles of the creditors in the voluntary liquidation process? As I said, that the creditors are supposed to give their claims within 30 days. If they are creditors, they also have to approve with the 2/3 of their majority the special resolution which was passed under section 59 subsection 3, that also has to be approved by the creditors. Then the creditors participate in distribution of assets. Then in the case of Nagarjuna Construction Company Limited versus ECR Infrastructure Limited, the process of claim verification and the creditor participation was highlighted. Then another question comes is, how are the assets distributed in the voluntary liquidation? The assets will be distributed under section 53 based on the priority as set out in section 53, and whatever is left, that would be distributed to equity shareholders after we even distribute to preference shareholders. This was clarified in the case of Sigma Corporation versus liquidator of Everest FinServ Private Limited in 2023. The role of secured creditors, in fact, was in the process of distribution that was in fact discussed in this case. Then there is another question: can voluntary liquidation process be withdrawn once initiated? The answer is also, you can find the answer in section 59 subsection C, that the voluntary liquidation can be withdrawn before dissolution if a majority of the creditors and shareholders agree to it. This was again discussed in Simplex Engineering and Foundry Works Private Limited versus, this was NCLT case. Then, like, what are the reporting requirements? As we can see that the reporting requirements is that the quarterly progress reports has to be submitted to IBBI and all the creditors and stakeholders. Quarterly progress report is must. Then the final report, which is to be submitted with the detailing all the asset sale, claim settlement, distribution, all that has to be done. In fact, there are many compliances, but today we are focusing on the practical issues, judicial pronouncements, what all has actually been so far decided and upheld by various courts. So what are the penalties of non-compliance or delay in voluntary liquidation processes? In fact, section 235 capital A of the IBC says non-compliance or delay can attract penalties of up to 2 lakhs for corporate debtor or liquidator. This was also held in the case of Innovative Industries Private Limited. It was a judgment from NCLT Kolkata in 2020. Again, we have another question which says that what happens if the liquidator fails to complete the process within the prescribed time? If the liquidator cannot complete within 12 days, the liquidator must apply for an extension, and with the justification of the reasons of delay and how the process would be completed thereafter. The Regulation 37 of the voluntary liquidation process regulations also permits extension wherever necessary. It is also clarified in the case of MK Agrotech Private Limited from NCLT Bengaluru. Regarding taxation and accounting, one thing is very clear, that all the laws are applicable during voluntary liquidation. All the income tax returns are supposed to be filed, TDS returns, GST returns, ROC returns has to be filed. And all kind of laws are applicable till the company is dissolved. The liquidator must ensure that all the tax liabilities are paid. All the tax liabilities are paid. Now, how to handle the contingent liabilities? What are the treatments of contingent liability which are affecting the liquidation process? In fact, the law says, the court says that the contingent liabilities must be addressed if the company has to be dissolved. It must be provided for. It must be assigned to someone for value. And then only the company can be dissolved. The liquidator must set aside funds to meet any contingent liability that may materialize before the final dissolution. This was held in Reebok India case by NCLT New Delhi. Then we have we have another question. What are the requirements of closing books of accounts during voluntary liquidation process? As I said, the liquidator must close the books of accounts and prepare a final statement of accounts before the application for dissolving the company is submitted, before the compliance certificate is submitted under section form and form H. Then it must be submitted to ROC, IBBI, and creditors, showing the liquidation process is complete. Regulation 38 very clearly says that the final statement is required. Now, the practical challenges that what we have, sometimes we have some untraceable creditors or untraceable stakeholders. So in that case, the IBBI has made public deposit account, and if there is any amount which is not claimed, that has to be deposited in that public deposit account. Regulation 39 is very clearly says the handling of unclaimed funds, and it was also kind of upheld in the case of RK Builders versus Vikas Constructions Limited. So this also provides the guidelines how to handle untraceable funds. Then as the challenges faced by the liquidators while realizing the assets, I think the liquidator must conduct the auctions and or private sales to maximize the recovery. And it will be very clear to say that the stakeholders, the shareholders, the management continues, and they participate into the entire sale process. This is again held in Ashok Leyland Limited versus liquidator of Deepak Traders, where the clarification was given regarding the role of market conditions and asset sale challenges. Now, there's another question. Can a company under voluntary liquidation initiate legal proceedings or continue existing litigation? So in the case of 𝐄𝐦𝐚𝐢𝐥 Developers Private Limited versus Karnataka State Financial Corporation, NCLT held that once the voluntary liquidation is initiated and liquidator is appointed, the company is deemed to have ceased its business except for the purpose of winding up. The liquidator, however, can continue litigation that benefits the liquidation process. Under section 35 of the IBC, the liquidator has powers to initiate or defend legal proceedings in the name of the company to maximize asset recovery. This is what has been held in the case of 𝐄𝐦𝐚𝐢𝐥 Developers Private Limited. Now, there is another question. Can the voluntary liquidation process continue if the company is found to be insolvent after initiating the voluntary liquidation? So this is also held in the same case, Krishna Enterprises versus Ratan Lal Agarwal, which in fact NCLT clarified that if the company is undergoing voluntary liquidation is found to be insolvent during the process, the voluntary liquidation may be converted into CIRP. Not in liquidation, it will be converted into CIRP, and the same liquidator can be continued as the RP for that company. So this is also has been held. Now there is another judgment which in the case of Sai Motors, which is from NCLT Mumbai, it is like, can shareholders challenge the appointment of a liquidator once the voluntary liquidation process has been initiated? No, in this case, NCLAT ruled that the shareholders do not have an inherent right to challenge the appointment of a liquidator unless there is a gross misconduct or non-compliance with the procedure of the IBC. Once a resolution for voluntary liquidation is passed by the shareholder, the appointment of the liquidator follows the provisions of section 59. So this is where even the liquidator in fact cannot be changed also unless gross misconduct or non-compliances are found. How the court addresses the delay in voluntary liquidation processes? Again, Innovative Industries Private Limited, the regulation 37 says that the liquidator must justify the time taken and why the extension is required. So then the extension would be given. Now, the liquidator's creditor's claim can be admitted after the public notice period. That is also was held in the case of Nagarjuna Construction Company Limited versus ECR Infrastructure Limited, that NCLAT says that the creditor cannot submit claims after the expiration of the notice period unless the delay is justifiable and the liquidator accepts the delayed claim under Regulation 16 of the voluntary liquidation processes. The liquidator has the discretion to accept claims that were not reasonably submitted uh, within the 30 days period. This was again a judgment in the case of Nagarjuna Construction Company Limited. The another judgment is Precision Steel Casting Private Limited versus Ethiopian Anklet Chennai. Are stakeholders entitled to challenge the liquidation expenses claimed by the liquidator? No, in this case, the court says the stakeholders have the right to challenge the liquidation expenses claimed by the liquidator if they feel that the costs are exorbitant or unjustified. Section 33, subsection 5 of the IBC court has authority to examine and reduce unreasonable liquidation expenses, ensuring that the liquidator adheres to the best practices in the cost management. Now the question is, can the liquidator sell assets below the liquidation value during voluntary liquidation? This was in fact held in the case of Kamal Industries versus Techno Trust Limited by ANCLAT, where the emphasis of the ANCLAT was the liquidator cannot sell assets below the liquidation value unless a significant effort has been made to auction the assets. No, Regulation 35 of the liquidation process regulation also says that the liquidator is bound by a professional obligation to maximize returns to the creditors. The court may intervene if it is found that the assets were sold at an undervalued price without exploring alternative avenues. This is Kamal Industries versus Techno Trust Limited. Now, can a voluntary liquidation be terminated after commencement and before final distribution of assets? Yes, in the case of Simplex Engineering, it is held that the voluntary liquidation process can be terminated if it is decided by the creditors and the shareholders. That can be terminated. Now, can a creditor initiate corporate insolvency resolution process during voluntary liquidation if the claim remains unpaid? This has been held in the case of Shyam Ferro Alloys Limited versus Union Bank of India by NCLAD in 2021, where it was clarified that a creditor can still initiate CIRP against a debtor under Section 7 of the IBC, even if that corporate debtor is under voluntary liquidation. That means that there is a default. That means that somebody is trying to initiate CIRP because of the default. So the basic declaration, the solvency declaration was wrongly given. So therefore, anyone can even file a CIRP application even if the company is in voluntary liquidation processes. It is held in the case of Shyam Ferro Alloys versus Union Bank of India. Now, again, another question comes: what happens if there is a discrepancy in the valuation of assets during liquidation process? So this was held again by ANCLAD in the case of Ravi Construction Limited versus liquidator of Malwa Textiles, where NCLAT held that the discrepancies in asset valuation should be resolved through an independent valuation process. If the stakeholders challenge the liquidator's valuation, the liquidator is required to appoint a third valuer. This is also provided in Regulation 35, Sub-Regulation 2 of the Liquidation Regulation, not voluntary liquidation, to ensure fairness in the transparency. So this is the kind of various judgments. Again, we have judgments. In the case of Praful Nanji Soni versus Registrar of Companies, it has been held that the voluntary liquidation does not absolve the company from statutory compliances unless it is final dissolution. And also, the delay in voluntary liquidation caused by external litigation may be permissible. It is again held in the case of MK Agrotech. And again, in the case of the secured creditor can opt to enforce their security interest outside liquidation, but if they participate in the process, they must adhere to the liquidation distribution priority. This is held by NCLAT in the case of Cigna Corporation versus liquidator of Everest Finserv Private Limited. And then the sale of assets below the liquidation value is also allowed. Not that it is not allowed. That has been held in the case of Ashok Leyland Limited versus liquidator of Deepak Traders, that it is allowed. The liquidator can prove reasonableness, reasonable efforts, and market conditions to say that. Now, we also have seen the we have already covered the step-by-step approach. One thing that I would like to see cover, there are there are some judgments which actually IBBI have passed against some of the insolvency professionals. That is in fact very important to highlight. In one of the case, the disciplinary committee of the IBBI has held that uh, in this case, the disciplinary action was taken against the voluntary liquidator for failing to comply with the timeline prescribed under the IBC regulations. The public announcement for voluntary liquidation was made 18 months after the commencement of liquidation. So therefore, the penalty of 1 lakh was imposed by IBBI. Again, in another case, in 2020, the the NCLAT, as like the NCLAT held that while rejecting the claim, reasons were not given. So therefore, NCLT says that the liquidator must give reasons while, in fact, rejecting a claim, and even IBBI also, I think, took some action against it. Then, in the public announcement was made delayed, so IBBI imposed 1 lakh penalty against an insolvency professional. Then the distribution of the proceeds were not distributed within the earlier timeline of 6 months. Then again IBBI took action and a penalty of 50,000 was imposed. Then in another case, the final reporting and the final reporting was not made properly. Adequate records were not maintained. So therefore, the penalty of 75,000 was imposed. It is not the penalty which matters. The matter is the show cause notice will be issued. All this investigation and inspection will happen. The AFA would be suspended. The penalty is not important. The important is the action against the and the overall some kind of negativity in the career also will come. So in another case where the public notice was delayed, so it was again a penalty was imposed. So in another case, this is very important. It is the case. It is a judgment in 2023 where the IP failed to file an appropriate application regarding avoidance transaction, despite identifying potential fraudulent transactions under Section 43 to 50 of the IBC during voluntary liquidation process. The avoidance transaction application was not filed, and the RP was in fact fined. So these are various issues. In fact, IBBI issued a circular in 2017 that the public announcement must be made in time, and another circular that was issued on 15th of November 2021 that the liquidator is not required to obtain an NOC from the income tax department. This was highlighted because many liquidators were delaying the distribution process by waiting for such clearance, and it is the circular says that under Section 178 of the Income Tax Act, it is sufficient to inform the tax authorities without requiring their clearance. Then the timeline of preparing the list of stakeholders was also reduced from 45 to 15 days in case there are no claims. So then there are some kind of proposal which are still to be converted into regulations. So Ankit, now we can actually see the questions in case we have questions. Because in fact, I tried to raise questions by myself so that all the important questions are covered. So then we can see what questions are now.
You'll need to unlock your iPhone first. The liquidator asks the contributories to pay unpaid contribution. Is it applicable only to voluntary liquidation or Section 7, 9, and 10 liquidation also? So whenever there are...
It is only applicable to voluntary liquidation only.
All right. But if there are contributories which have not yet paid their share capital, technically it should be something which is receivable by the company in other cases also, in case it is an arrears. But
Somehow I couldn't
anyways,
find anything in the
maybe it's
regulation.
not practically too
No, no,
much.
I think I couldn't find anything in the regulation, whereas in the voluntary liquidation regulation, it is specific because that is impacting the shares of other shareholders.
But the General Companies Act understanding is that if there is unpaid share capital, then that can be asked for by the company. But the replications are forfeiture of shares and all that, which may not be applicable here. Then, whether the directors of the company get suspended from the date of commencement of liquidation
No, 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 not at all. The
doesn't
directors
happen in
continue.
voluntary liquidation.
Directors continue. This is not a suspended management. This is a management. The shareholders continue. The directors continue. The board of directors will continue. And rather they will participate into they will monitor the sale of asset, realization from the asset. They can monitor all that. But they will not have power to sign a bank account because the only one bank account will be operative, that is the liquidation bank account.
So, a very practical question from Mr. Dhingra. He says that for 7 months, company was working, then voluntary liquidation was approved in EGM. And then for tax filing purposes, do we again wait for 7 months, close the balance sheets, and then wait for the refunds? How do we process the voluntary liquidation in this scenario where the company had active operations and maybe some tax filing or returns are pending, balance sheets are pending for that period?
In case the company stops businesses, I think in the section 176 of the Income Tax Act provides for filing a return up to the date of the decision of the company to liquidate. So the company can finalize its own statement and can file a return even before closing the financial year.
When company records are preserved by directors and voluntary liquidator records are only preserved by liquidator. The declaration by directors also provides the same. So I think Raviji is simply confirming that this is what needs to be done.
So the liquidator will have to assure the liquidator will have to assure that all the company records are preserved, and the liquidator will preserve whatever records and reports he has created for 8 years. But the liquidator must assure in the final compliance report that the records of the company are preserved by the directors and how it has been preserved.
So if a company was formed but did not commence any business operation and only a bank account was opened with a deposit of 5,000, which was later closed, with the entire rupees 5,000 being deducted by the bank as charges, can the company be voluntarily liquidated? In this kind of a scenario where the company never had operations, one option is, of course, to have the voluntary liquidation, but I think it will be more expensive a process as compared to strike off. I think the facts of this position or this company are more appropriate for a strike off application to be filed. That might be better. When a charge is registered against the borrowing, whether the filing of e-form CHG4 is compulsory if the same is reflecting on the MCA website after the commencement of voluntary liquidation, even if repayment has been done and there is no outstanding.
So all the ROC compliances are supposed to be done even if the liquidation process is commenced.
So
All
the satisfaction of charge is required to be taken up.
absolutely.
And if it is delayed and if it requires some kind of condonation, then that needs to be
The
taken up.
normal company law provisions will be applied. There is no concession.
Then we have Mr. Kabir asking how the sundry creditors claim will be handled when the company applies for voluntary liquidation. As you said that the secured creditors can stay out of the voluntary liquidation process.
They can choose to stay outside.
Can choose.
They can choose to stay outside and they can realize their security, and then they can report to the voluntary liquidator that this is what is our loan and this is what is the value of the security that we have realized. Again, those similar processes which is there in the liquidation process, when uh, the secured creditors do not relinquish their security interest in favor of the liquidation estate. And then there are two processes which is defined in the liquidation process. One, in case the SURFACI Act is applicable to those creditors, then there is a different process. In case no SURFACI Act is applicable, then there is a different process. So those processes would be applicable to voluntary liquidation also in the case of secured creditors.
So then we have, what is the difference in distribution of cash reserves in voluntary liquidation versus vis-a-vis the CRP failure-led liquidation? So in any CRP failure-led liquidation, the premise and the normal course would be, a normal understanding would be that the shareholders would most probably get nothing, and we are only looking at maybe, attempting to make any payments to the secured lenders or the other creditors. Now, in this case, in case of voluntary liquidation, we start with the premise the company is solvent, and therefore the reserves or surplus in normal course will be available for distribution to the shareholders, or they will be just enough to take care of the liabilities. That's the major difference, I guess.
No, I think the answer is very simple. The shareholders can take haircut, but no creditors can take haircut.
Hmm.
Contingent liabilities has to be managed, has to be provided for, and any kind of litigation in case it is pending, or any kind of investigation if it is pending, the company cannot be voluntarily liquidated. So no creditor uh, can actually say that yes, uh, I will take any haircut in the case of voluntary liquidation, unless it is settled mutually.
So then we have a question that what complexities have you encountered regarding tax liabilities during voluntary liquidation process, and how do you advise clients to manage them?
What I see that in case there are substantial tax assessments pending, I have seen a couple of judgments where the since the assessments are pending, that doesn't mean that the company cannot be liquidated. So the only thing is that somebody has to take the obligation that in case of any tax liability, and that particular provision would be made that the tax liability in case, however, in case the assessments are pending, then the liquidation can still happen. But in case the demands are pending, then it has to be provided for. Then it has to be provided for. Somebody will have to take the responsibility that he will pay the liabilities and the company can still be liquidated.
Right. We have a
It's
lot of
the only
questions
practical
now.
part
I
of
think
it.
we will have to take them offline because we are crossing our time as well. So I think we will have to request those whose questions are still unanswered that we'll have to take these questions offline. So I think that's the way we can do it.
So Ankit, our team actually has done a wonderful work. So too many judgments found and then finally analyzed. So it takes a lot of time, even finding the IBBI orders on the voluntary liquidation, something which is significant to mention again, that avoidance transactions like accept 66 or all are applicable, but that would be only to uh, kind of impact the shareholders' rights, not the creditors, because the creditors aren't getting full amount, but only one who would suffer would be the shareholders in case they are actually taking a haircut. So the PUFE transactions are important, and I still feel that not in many cases the transactional auditor has been appointed, but the IBBI says that in case the avoidance transactions have been noted, it was also in the knowledge of the IP, but it was not reported to NCLT. That is where the question is. So therefore, in most of the cases, the avoidance transactions should be noted, but not for defrauding the creditors, but for defrauding the shareholders, because the creditors are getting their full amount in this case.
Right. All right. I think so. Let's. This is a good, very practical insights that we shared. So I think let's take the remaining questions offline, and we'll see everyone next week then.
Thank you very much. Thank you for participating and keep encouraging us. Thank you. It is our way of learning.